All right, it's another exciting video. This is, as I always say, is an unusual one. I just completed an appellate brief, a filing in time that I've worked on for the last, 72 intense hours. And prior to that, I do an appeal maybe once every 3 or 4 years, either in Florida or Michigan. I've done a couple on the federal level, the Court of Appeals, one step below the Supreme Court with a published case. So while that's not my specialty, what I'm here to tell you today is, believe it or not, even appeals at the very highest level all emanate, seriously, from the counter affidavit. I S you not. This counter affidavit that I preach to you every day can go so far with you. In this case, I appealed a summary disposition order against my client where the court believed that the other side had made a great case that they owned the debt that they were suing my client on. And from day one in that case, it drove me crazy because even their initial lawsuit, which went uncorrected all the way up to summary disposition hearing, said that the company then, Velocity, had defended my client had become indebted to Velocity on the day that he received the funds, which would be an impossibility because Velocity only gets involved once of the default on the debt. And in that case, as in many of the videos I do, this was a Cross River bank that gave the money to my client in 2018, and Velocity didn't get involved until 2020. So that and other clearly obvious reasons why Velocity did not own the debt made me believe I was going to win this. And the court, and I'll get into this as to why you take an appeal. Not all cases are appeal. The court infuriated me, and sometimes my emotions get the best of me, but that's what makes me or you who you are or who I am. So I'm coming at you from this viewpoint. So when I do an appeal, I'll go online. What's the best way to do it? Depending on what court I'm in, is it going to the Court of Appeals? Is it going to the Supreme Court, depending on state or federal? So you look as you do for help online. And again, I noticed that the most important thing I think I'm going to give you today is the thing that I looked for. So I'm coming at you from my own personal experience of looking for a word template that fit my needs as far as doing this appeal. So I'm going to give you what I was looking for. I wrote this 20-page appeal, and I'm going to give it to you in Word along with the table of contents. Now, the table of contents sounds easy, but it isn't. It's a whole thing. When you do an appeal, with no disrespect to anybody, you're dealing with people with OCD. That's the way I look at it, because I have it. And every minute thing must be a certain way when you appeal. And it's agonizing how you've got all this work to do on the appeal brief, but you've got to do these other minor ticky-tacky things that drive you crazy because they have to be done and done the right way. So why do I appeal? Why does one appeal? For two reasons. Because I'm pissed off at a court that clearly was in error. And remember that word error, okay? Or I see it, on the horizon that my specific case, and this was the case in this appeal, really there's very little case law showing why I should have prevailed. But the two cases that there were both in my favor. And there was no contrary cases on the other side supporting the debt buyer. It's very hard to have a debt buyer case because if there's really not going to be a support saying, yeah, you brought everything. It's usually something's missing, and that's the reason why a case is appealed, or the court didn't review something. It was an error, and that's why the case is appealed. But in the jurisdiction that I was in, I'm not explaining this well, there was what's called a dearth of case law. But if the few cases existed, by the way, one of them was mine, they were in my favor. So they were in my appeal. So I looked at this and said, we need something that cements and locks my beliefs about you've got to have a perfect chain of title to sue in a collection case. So if I win this appeal, it will be land breaking because there'll be finally something cemented and not just my theory and my hard arguing, developing these things. Again, the other side has a burden of proof. So the appeals and successful cases are going to come from the defense, my side of things, showing that when you regularly get burned because the judge doesn't want to deal with you or doesn't like the fact your client owes money. So while I was very angry, and that used to drive me as a younger man, I saw that the landscape in my area needed more case law. So my client agreed to appeal this. It's to their benefit. So let's quickly look at definitions. Cindy put these up. Shazam, an appeal. You're just seeking a higher court's review of a decision made by another court that, in my case, they were wrong. And I'm not just saying that as an advocate. The judge was so wrong because you can see, not just from my documents, because I used, by the way, as I do anywhere else, their documents against them. And their documents were so bad, they themselves, in the reply to my response to their motion, started twisting things and changing titles of companies just to fit into this thing that they knew they didn't belong in the first place. So that's what an appeal is. And get used to these two terms. Appellant is you. You are appealing. So you are the appellant, and the one you're appealing is the appellee. So if you want to do it like this, the payor in a check is you paying, and the guy receiving your money is the payee. So the appellee is who you're appealing against, or they've won, you've lost, so now you're the appellant, and they are the appellee. Two types of appeal. There's one, the application for leave to appeal occurs where you kind of don't have an automatic right to appeal, or you missed the time period on your claim of right. So there's an appeal of right. In my case, my client had the right to appeal in the first 21 days, and he did that. I filed the claim within the 21 days. I just yesterday won a motion to reinstate an appeal during my claim of right, meaning I have the right to appeal for 21 days without asking anybody's permission. I got my claim of appeal in 1 day before the 21 days was over, but the court was going on vacation. It was New Year's Eve. And so the clerk literally must have just put it to the side, and the thing wasn't filed until 10 days later. So the court record showed that I missed the deadline. It took me 2 motions and anxiousness to finally get a judge who smartly ruled yesterday. He said, yeah, I could see what happened. And that's nice where there's a human, but up until the end, the court is like, well, you missed the date. And he accidentally revealed that, oh, I do see you got it in time, but officially the clerk didn't docket it till 10 days later. But there was no hard and fast rule that says a clerk docking it is when it gets in. If there was, then you'd have that 21 days would mean nothing, because the clerk was, maybe she's got a cold, so she just waits a couple of days, ruins your claim for appeal, your right to appeal. Had I lost that motion yesterday, my right to be reinstated, to file my claim of right, I would have gone on what's called, I'd apply for a leave for appeal. I'd have to go back to that same court that ruled against me and go, hey, I missed the deadline. Can you let me do it anyway? So keep an eye on those deadlines, man. Don't miss those deadlines. So The second most important document when you are appealing is the transcript of the hearing that you are saying an error was made or something went wrong. That's one of the first things you do, and you notify the court reporter that you want to order the transcript, and that's a sign to the court that you aren't happy and you're going to appeal. So that has a bunch of stuff going with it. No big deal. And depending on what level you're appealing to, you're then dependent on the court reporter getting that document back to you so you can say in your appeal, hey, here's the transcript, because that's a requirement in most appellate moves. However, most appeals court also let you say, I have ordered it, rather than actually have the thing to show the court in your claim of appeal. And that's what you do. You just file a piece of paper with a bunch of documents with it. The second most important document being that trial transcript or proof that you have ordered it within the 21 days. The most important date is the most important document, and that's when you have to file your appeal brief. That's what we're going to be talking about today. In my motion yesterday to reinstate my appeal of right, my leave of right, as soon as we're done and we won, the court said, okay, when's the brief coming? Because that initiates everything. You've got to do it within a certain amount of time, and that's what we're talking about today. So prior to filing the brief, the important appellate brief by you as the appellant, and then the appellee has a right to reply, and then you have a right to reply to their reply. So these are the documents you're going to be looking at. And Cindy put these up. Shazam, the filing fee, of course, it's all about the money. A bond. If you are at a certain level, let's say you lost and you owe $10,000. In some cases, you have to put up a bond for that $10,000 to put a stay on everything. Meaning, you can't, if you're appealing something that went against your defendant client and now they owe a judgment and that's what you're appealing, the execution on that and the collection of that will automatically stay at some levels in some courts. But on the other cases, there isn't an automatic stay, and you have to put up a bond for a certain amount that covers potentially what you may lose and the costs of your appealing this thing and the cost to the other side. So, but again, check your court rules to see if there is or isn't an automatic stay. If there isn't, you may end up putting up a bond. You can also, as an indigent person, seek to waive that bond, seek the court's ruling on that. And courts aren't so thrilled at doing that, by the way. They want this out of their hair, and you're appealing their decision. So proof of service is one of the third most important document. You get gigged all the time on these things if you didn't serve the other side, if you didn't serve the court and didn't do a proof of service. Proof of service more than you need. Proof of service. Do proof of services on everything. Do a proof of service on your proof of service. Yeah, you can do that. Because that's where you get gigged on these things. The original claim of appeal is a form that you fill out, and it's available online, PDF. It lets you fill it in along with everything else. You're going to need a copy of the order of judgment that you're appealing, a copy of the trial docket. You get that from the lower court. The jurisdictional checklist, that again is a fill in the blank form that is available online in your state, a docketing statement, easy peasy. And again, the statement from the court reporter and you that you have ordered it and it's signed and you can prove that you're not just saying that. All that information, that list has to be included in your, just to file a claim of appeal within the 21 days, but this isn't that hard. There are 3 standards of review in most appeals. So I just told you earlier one about an error. So the 3 standards of review are clear error, and that's when the challenge ruling includes finding of facts that clearly were wrong. And that's kind of my thing, but down the road here, you're going to see how I went in. Abuse of discretion. When a court rule or statute gives a court discretion, meaning they may want to do something as opposed to they have to do something, trial courts review that decision for abuse of discretion? Did they go too far in depending on the may by either not doing what they should have done or did too much? And the rule is, in some cases, an abuse of discretion occurs when the trial court chooses an outcome outside the range of principal outcomes. Now, here's my favorite. De novo. That's the third level of review. That's what I went in yesterday when I finished my appellate brief. It means you're really just doing the whole case all over again for the reviewing panel, for the appeals court. Well, you've done all the work. You did your counterclaim. You did your answer. You did your counter affidavit. You've done your response to their summary motion. They've got their summary motion. They've got the reply. Everything's been done. The Court of Appeals, in this case, considers the case or issue that you're bringing in independently, as though the trial court never ruled on it. They become, in a sense, the first trial judge. This, again, usually applies to summary motions. That's what I'm appealing. The court, in a summary hearing, went against my client and clearly wrong. So I'm going de novo. I'm essentially saying, hey, you guys look at this. Am I seeing things here? Where did she rule the way she did? So let's talk about writing the appeal brief. All right. So I'm going to put up a list for you. Cindy, put up on the screen the following. Shazam. Number one, you have a lot of ticky-tack tasks surrounding your brief that you write. I mean, enormously ticky-tacky that just drive you nuts. And you want someone else to do them for you, but you can't. You've got to do them. So the quickest way to do those ticky-tacky things, and I'll get to them, is, this is my number one pro tip. Write the damn thing. Just write the brief. Don't worry about all that other stuff. You may not even be ready, but I'm a would-be writer. If I given my druthers, I would write for a living. And the number one lesson that every book that I've read about writing, because I'm reading, not actually writing, is just start writing. And that is so true. Once I sit down and start writing, it all comes to me, right? I've done my research, I've done my work. It just flows out of my head into my fingers. So that is so true. That's the best tip I can give you. And I'm going to show you why that's the coolest tip. Because you have a number of things to create for the court. The table of contents. So let me put up a table of contents. Shazam. That is all the things that need to be included with your appellate brief. Not just the brief, but an index of authority, statement of appellate jurisdiction, statement of questions or argument you're making, appendix of exhibits. All of those things can be avoided until after you're done with the brief. Why? Because a lot of the things that go in those indexes or exhibits emanate from your completed brief. For example, your index of authorities, what that is the case law and statute you relied upon. We don't know that until you're done, because you're, as I write, I'll go, oh, I wonder if there's a case that supports that. Boom, I go find a case. And so you won't have your index of authorities done until your brief is done. Statement of appellate jurisdiction, you don't need to finish the brief, but just wait. Statement of question or argument, you can write that statement. What that is what's the issue or issues that you're pissed about. So you do like a large sentence of showing the court, hey, the court ruled this way without any proof or justification. But when you're done with your brief, that is changed, because the brief writing, your writing, takes you in a direction you would never be able to find or discover or learn about until you start writing. So start writing, and the number one issue that you're mad about can evolve or morph into something more finite or concise. Or really the point, maybe once you go through, you're like, oh, wait a minute. This is what, like, I read the transcript and the judge made a throwaway comment that I hadn't noticed before. But I only noticed that because I kept writing the brief. And as I will show you, I took her quotes and batted her for them. So don't do anything else until you finished your brief. All right? Just start writing is my key to writing the brief, as I said. You've done a counter affidavit and a counterclaim and your summary response. You already got everything, but you don't, because this is a year later from when you wrote that stuff. So that's your skeleton. You've got an outline already. Just take your summary response and add what you need to and start writing again. Maybe there's a new case. For example, in what we've talked about previously is the Green versus PRA. That wasn't available to me when this particular appeal first was initiated. It now is, and a side note, people are so pissed about Green versus PRA, meaning the bad side of the debt buyers, they've asked it to go on an en banc review. So it's in hold. So you can't take this great decision or the ruling and use it. But what you can do, and is what I did, I took the cases from the decision because they were good, and those cases are still good. They haven't been stopped from being enforced. So I used those to support my appellate brief. Your depositions, if you've taken depositions, I took a Butte, the custodian of records of Velocity literally said what I said was wrong with the case. In this case, they had a bill of sale, and this is common with Velocity, and the company, this weird trust, MPLI, had given the documents or the receivables or the judgments or whatever, including my client's debt, wink, wink, to Velocity. Boom, case over. But 6 months later, the original creditor, Cross River Bank, gave the same debt to somebody else. So how could they say Velocity received it 6 months before the creditor actually gave it? I SU not. That's what happens in these things. So there's no way the court that ruled, yeah, they own it, could have said that just by looking at that alone, the time. So I said to their custodian of records, how did MPLI get the debt to give to Velocity? She said, I don't know. Well, she should know. She's the custodian of records, the main witness to show the chain of title. I go, have you ever seen an assignment giving it to MPLI so they can give it to Velocity? I have not, is what she said. So that's in my appellate brief. I took her words favoring me. This is why I got so mad about this case. It's clear that I'm right. Use ChatGPT. Attorneys are getting their ass kicked because they're depending too much on. The way to depend on it is in your writing and your editing. Like I can take a day or two just editing and rewriting, or I give the same thing to ChatGPT and say edit and rewrite and make it sound better. It does it. So that's good enough for me. You got to check. Always check, verify. But as for case law, this is where attorneys are getting killed. Don't depend on ChatGPT. It literally makes cases up. I've seen it. I've actually given ChatGPT a request on a case I knew up and down, and it came back wrong. And then I said, hey, you're wrong about this? It said, yeah, you're right. It actually admitted to me. So be careful. Trust but verify. So when I did this, the thing I'm appealing that got me so mad, I spent 5 to 10 pages of the transcript. So I'm going to put the transcript, Word template of the appellate brief so you can use it. The table of contents, believe me, it's a pain in the neck to create. You can have it in Word. My show notes. I'm also going to throw in my motion, now that I think about it, to reinstate. In case some of you all get into a bind, you can use my, motion to reinstate if you want. But I spent a great deal of time explaining to the court exactly why their own custodian of record said there is a break in the chain of title, how the other side, Velocity, had just messed the whole thing up and would not explain how the debt they said they had was not given to somebody else until 6 months later, and 6 months after supposedly Velocity got the debt that hadn't been sent yet. I hope that makes sense. And the complaint of the actual lawsuit of Velocity said, my client defendant became indebted to plaintiff Velocity upon receipt of the funds. Well, the receipt of funds occurred between Cross River Bank and my client in 2018. The lawsuit was filed in 2023. Velocity may have got this debt in 2020. So that alone was false. It went uncorrected and it was not amended. So that's what the summary motion is saying to the court. Hey, rule in our favor because this is true. It can't be true. The documents, their own documents, by that statement alone, Velocity could not have become, defendant was not indebted to the Velocity upon receipt of the funds because Velocity wasn't around for 2 or 3 years until 2 or 3 years later. But for some reason, the judge, this is what happened. I told the court all of that. The other side, when they were asked to explain their case, they weren't given any questions. It was just their turn to talk. Just, it was basically, I'm a jerk. We do this. Parker's a jerk. Parker's a jerk. So the court, after hearing my detailed examination of my documents I presented to her, showing her clearly how the chain of title could not exist to give them standing, said the following. Thank you, after I spoke. Having reviewed plaintiff counter-defendant's motion for summary as to their primary claim and as to their counterclaim, they did not file a counterclaim, I did. My question is, it's my understanding there's a clear chain of title, right? And she's asking the other attorney. The other attorney says, yes, I think that we've laid out in clear terms the documentation as well as the sworn testimony of our witness. Remember, that's the testimony of their witness that said, Parker's right. We own it. The court said, well, good enough for me, thank you. The court, having reviewed the motions, hearing oral argument, considering all the evidence and other pleadings, a complaint is a pleading, a motion is a motion. Well, the only pleading really is the complaint that said they became indebted, defendant became indebted to them 2 years before they actually even existed. So why did she say that? The court is going to grant plaintiff counter defendant's motion for summary disposition. That's what drives you crazy. And she did this throwaway thing that really bothered me. The pleading suggests that there is a clear chain of title. Velocity was the assignee of this loan, and that there was no objection here by the defendant as to actually taking out the loan for $45,000. That's what I noticed as I was writing. Why would she say something about the money when it's about ownership? Whether the client owes it or is paid or anything really has nothing to do with if they have standing. 3 years after they claim my client became indebted to them, after the client became indebted to the loan company, what's money got to do with it? So when she said that, I'm like, aha, she's mad because the client will get away with $45,000 in debt if she rules for me. Why else would she throw that in there? It's got nothing to do with ownership. That's the only, and so that's the issue that that's what you have to do you have to come up with the issue that drives you. So I say write the appellate brief, but have the skeleton of the issue. In my case, my issue was they have not shown any ownership. And I'd made a great detailed case for that from day one. And I said the court was wrong because the court had nothing to stand on. So when I say the court is wrong and has nothing to stand on, how far can I take that? What can I say about the court that isn't going to get me in trouble? Trouble is a weird word, but you want to show the court respect because you're dealing with 3 other judges that, they like respect too. They have come, becoming a judge is not easy. It is to be respected until they fall out of parameters and start being personal or something. But as long as they're neutral, I'm okay with that. I don't see neutrality here when you're not looking at my pleadings and the other side's own witness said Parker's right and you ignored that. So what do? How do you poke it in the eye of the court? Here's what I wrote. Velocity's own document showing its failure to prove ownership of the debt, and the answer, affirmative defenses, counterclaim, and summary motion was available to the court. Hello, read. And then I wrote, yet the court failed to take note of any of this and ended the summary hearing by just seeking Velocity's verbal confirmation that Velocity was assigned the debt. So that's why I read that to you. That actually happened. And then I put that in my appeal to the higher court saying that's what happened. And I ended a couple of others where I wrote, yet the court failed to provide any reason or support overcoming this in the absence of assignment of the debt from the originator of the debt, Cross River Bank. So you poke. So the last thing I wrote to bring it all home for the court, Cindy, put up the 1 through 8. I showed the court, the appellate court this, Shazam. I literally said, how is all this true? And it was, and the court still went against me. There's no assignment showing Upstart Network transferred anything to Velocity, and that's totally true. There's no document showing an assignment of rights, title, or interest of the debt to MPLI. That's true. Their own custodian records admit it. The lawsuit remains unchanged, even though it still states defendant became indebted to plaintiff upon receipt of the funds, when that is impossible in 2018. That is true. The custodian of records states she's not seen an assignment of the debt being passed to MPLI. Also true. The custodian of records states that the bill of sale is incorrect. Yet they filed the summary disposition motion with the incorrect one that their own witness said is false. She actually testified in the deposition, whoops, there's a grammatical error, we're really not that. There are no assignments or transfer documents of the subject debt signed by Velocity. That is true. In Michigan, in this case, the person that claims they own it has to sign. They have to be the party charged, who has interest in it. They sign nothing. There was no sworn affidavit of support attached to the motion or reply ratifying everything they were saying. That is true. There's no amendment of the lawsuit that the summary motion was based upon. They didn't amend that lawsuit. That was total misrepresentation. So this is what you get up against and why one gets mad. But be respectful and don't lose the anger. Have the anger drive you, but always keep respectful. Because as I said before, she tipped me off just a couple of days ago. Tipped me off meaning, aha, when she said that my client is essentially has not objected to taking out the loan for $45,000. Got nothing to do with it as to whether or not they own the debt and there's a perfect chain of title. So that was a tip-off. So look for those things. So take your time when you write the brief. Give it at least 5 days to do it. Get away from it. Like I got away one evening. I'm sitting there watching TV. And I mentioned to somebody blah, 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 blah about it. And they go, oh, that doesn't make sense. Why would blah? I go, bingo. So I throw myself at things with everything I got. That's not always the way to go. Do that, but also get away. Working out, running, your brain gives it a rest and then it goes back to working for you. So give yourself 5 days. ChatGPT is good, but trust but verify. On my website, I'm giving you the Word Template Appellate Brief, the Word Template, when I say my website, collectionstoppersolutions.com. My membership website's got about 150 videos, all the templates you need for your own self-defense. I'm not telling you how to practice or how to live, but these are templates. These videos are instructions for you to go get them in your state. So on this video, look for the Word Template Appellate Brief. I did not see that online. There you go, you can have it. At least the structure is good. And I used cases from different states in the US. A Word Template Table of Contents. This ticky-tack stuff drives me nuts. It will drive you nuts too. I've given you a Word Template body so you can fill in your blanks. But don't do any of that until you've written the brief, which will transfer over to this, let's just call it the appellate table of contents that has all these indexes and things you got to fill in. You got my show notes if they're of value to you. the transcript of the hearing on the ruling I appealed. Why not? Check it out. See what everything that you do. See how little the other side did, and then I kind of don't win. I'm not mad about that. I'm mad because here's why I'm mad. Clearly, this judge didn't do her job. She did not take the time to. I don't even know if she read the other side, because she literally said to the other side, "You assigned the debt, right?" That's all they freaking said in their brief. They didn't support it. So why ask that? And she just came at it from the wrong standard. And it was clear she had not done the work that the county taxpayers were just asking her to do. And we worked really hard on that and didn't make a difference to her. So that drives you nuts. So be mad, but be right is my 1A tip. And if you are, write that brief. Remember, the first step is to write that brief. Once you've done all the other ticky-tack stuff of filing your claim of right, or if you have to, seek the court's leave for right to appeal. I also will put on my website, just throw it in there for you, a motion to reinstate in case you get into that position. It may help you, I don't know, but it's on the site for you. So go to collectionstoppersolutions.com for this video and the templates. Hope it helps. Let me know. Like, love, subscribe. Brian Parker out.